One of the goals of the Rhode Center is to try to make the civil justice system more equitable, more transparent, and more accessible. The transparency project that we are working on, I think, really sits at the center of those aims. For the past roughly 40 years, there's been a debate about transparency in civil litigation. And the debate has centered on two fronts. One of those fronts is on protective orders and orders to seal. Another strand of our research looks at confidential settlements, sometimes called secret settlements or settlements with non-disclosure agreements or NDAs. And so our research is looking at both facets of the litigation secrecy question.
The Transparency Project is, we believe, a groundbreaking effort to try to do real empirical work on questions around how open and transparent the civil litigation system is. In this project, we have built two massive data sets, one at the federal court level and one at the state level, and we are going to shine empirical light on a bunch of questions that have echoed throughout those debates from the start. Our goal was to try to put real empiricism, real data on a number of questions that have echoed throughout the debate on transparency within the civil litigation system.
What we find is, I think, pretty substantial. We find that stipulated POs are about twice as common as previously believed, that they are almost always granted. In fact, about 96% of those were granted over our study period. We find that oftentimes the orders the judges sign don't mention the standard of good cause for entering these things. We've found that oftentimes there's no justification for secrecy in the order at all.
When we're looking at confidential settlements, a big question is do cases still settle, even if the defendant can't get secrecy? What we found after a huge amount of data collection and data analysis using cutting-edge natural language processing tools is, yep, defendants still settle.
Our goal is to discipline the debate, to show meaningful empirics and allow legislators to have the tools they need to meaningfully interrogate these questions.
It's one of those only at Stanford projects where we needed to really move the dial on this really important question.